the release of a draft proposal seeking public comments on some amendments to Information Technology, Intermediary Guidelines, and Digital Media Ethics Code Rules 2021 and its hasty withdrawal has offered some glimpse into the government's plans vis-à-vis social media platforms. The Ministry of Electronics and Information Technology, or METE, had come out with the new IT rules last year, which came into effect from 26th May 2021. The rules put in place a framework for content regulation by online publishers of news and current affairs content and curated audiovisual content. The aim of the 2021 rules was to make social media and internet companies having more than 5 million users more accountable for the content on their platforms. The 2021 rules had mandated that social media intermediaries publish rules to curb posting and sharing of content which is inflammatory, objectionable, hateful, racially and ethnically objectionable, etc. The online intermediaries were also told to appoint a nodal officer in India who is available round the clock to help law enforcement agencies. Through the rules, the government had prescribed a three-tier grievance redressal mechanism. But so far, if any user was not satisfied with any social media platform's grievance redressal system, he had only one option, and that was to approach the court. On 1st June, the draft that METE had put on its website proposed setting up of government panels to address such grievances. The draft was taken back the next day for some changes. So, before the government amends the proposed amendments to the IT rules and comes out with a new version, let us see what all it had proposed. One of the key proposals of the draft was that the government would establish one or more grievance appellate committees, which would be made up of a chairperson and other members appointed by the government. Under this amendment, a user would be able to appeal a grievance officer's order in front of the committee within 30 days of receiving it from the former. For its part, the committee would have to endeavour to resolve the appeal within 30 days of receiving it, and the concerned intermediary would have to comply with every order passed by the grievance appellate committee. The 2021 rules did not have a provision for such a grievance appellate committee.
I believe the grievance appellate process and mechanism that's been sought to be brought forward in the rules is a right step in the right direction, because the IT rules 2021 were pretty unclear. What happens if you're not satisfied with the decision of the grievance officer? Now, one option is that you can either have to file a lawsuit, because most of these social media companies are not state, therefore you cannot take them in the writ jurisdiction. At best, you'll have to file a suit for damages, for injunction, and appropriate directions. Now, for the first time, an appellate mechanism has been put forward for people who are not satisfied with the grievance officer's decision. That's one more level that's been added so as to reduce the ultimate quantum of litigation that's going to come forward in the context of social media disputes. I think any kind of addition of new compliances could be seen as onerous, but we have to ultimately look at a golden balance, a harmonious golden balance between protecting the rights of the users on the one hand and also protecting the rights of the intermediaries to seamlessly continue doing the business in India on the other.
The draft said that an intermediary would have to acknowledge a user complaint received by its grievance officer within 24 hours. This would specifically apply when the complaint in question is about user or account suspension, removal, and blocking. Also, if the complaint is for the removal of information or links that infringe copyrights, are pornographic, or are defamatory, among other things. The concerned intermediary would have to respond to requests for removal within 72 hours. However, the draft also said that the platforms were allowed to set up safeguards against the misuse of such provisions. Under the 2021 rules, an intermediary had to acknowledge a complaint sent to the grievance officer within 24 hours and dispose of it within a period of 15 days from the date of receipt.
I believe the reducing of the time effort or the time period for redressal of grievances may appear as news or may appear as music to the ears, but I think it still does not meet the expectations of the general public. Under the existing IT rules, if you do a grievance with a grievance officer, the officer has to acknowledge it within 24 hours. If the grievance has got to do with something which is pornographic or obscene, the content has to be removed within 24 hours. For all other non-sexual grievances, the existing time limit is 15 days. The proposed amendments are seeking to reduce the time limit for redressal of grievances from 15 days to 3 days, which I think is a great step forward. But then you still are allowing the intermediary to have the license to let on the criminal activity continue unabated on its platform and let the user continuing to suffer on a 24/7 basis for the next 72 hours after the grievance has been filed. I think that's neither very reasonable nor very fair to the users. Yes, from the standpoint of intermediaries, it requires added inputs, added efforts, but then hold on. Intermediaries are taking the cream out of the Indian market. They are ultimately earning out of Indians' data. They know fully well India does not have a data protection law. They are merely taking the data of Indians outside India. They're monetizing the data. They're doing everything possible to generate all kinds of money from the data and information that their users provide us. Now, here for the first time, the law is saying, hey guys, be more accountable. Try to be put in your mechanisms so that you can address your grievances within 72 hours. On a personal note, I would have expected that the time limit would have been reduced to 6 hours because on the internet, every minute is one age. The Supreme Court, in the case of Shreya Singhal versus Union of India, categorically had that intermediaries cannot be judges. So we don't even want them to be judges. We said once a grievance has been brought to you, please go ahead and remove it. So I don't think this 72-hour period is a much shorter period. Please understand the intermediary is not required to issue show cause notice, is not required to issue call for responses, nor is it required to get or lead evidences on one side or the other. It's not a court. It's only a service provider. And it's only been asked to remove certain content, which is in violation.
Under the 2021 rules, big social media platforms such as Facebook and Twitter were also mandated to enable the identification of the first originator of any information that undermines the sovereignty of India, security of the state, or public order. It is clear that some changes to the country's technology and social media regulations are in the offing, even if we don't know their exact contours at the moment. This will have a significant impact on social media giants, for whom India is a key market, which has not saturated yet and has upside potential left to it. According to Statista, more than 50% of India's population was accessing social networks in 2020. By 2025, it is estimated that social network penetration would be 67% of the country's population. As of February 2021, affordable data and mobile phones, along with the government's Digital India initiative, have resulted in India's digital population reaching approximately 624 million active users. According to Statista, India is the world's second largest internet market at this stage. However, even with the overhang of possibly onerous regulations, India is a market social media and tech giants cannot afford to ignore. And that's not just because of its size, but also because of the revenue it generates. As domestic media companies have lost ground and revenue, Google and Facebook have emerged as the main beneficiaries of India's booming internet advertising market. According to a media report, recently the combined ad revenues of Google and Facebook came out to be higher than the combined ad revenues of the top 10 listed traditional media companies. However, one major concern, which is whether or not the now withdrawn draft proposals or the ones that will come out soon will lead to enhanced government censorship, needs to be addressed.
If you like this video, share it and subscribe to Business Standard. For more news, views and insights, log on to www.business-standard.com. Do also follow us on YouTube, Twitter, Facebook, Instagram, Telegram and LinkedIn.
सब अच्छी दिख रही हैं यार, कौन सी खरीदूं?
ये तो वही बात हुई, 4000 शेयर्स लिस्टेड है, कौन सा लूं?
वो तो सबसे आसान है।
तुझे 5 पैसा नहीं पता?
अब तो सबको पता है 5 पैसा पर है 4000 स्टॉक्स की रिसर्च, टेक्निकल टूल्स और इन्वेस्टमेंट आइडियाज। डाउनलोड 5 पैसा नाउ।
अब तो सबको पता है investing made easy and rewarding with 5paisa. Investments in securities market are subject to market risks. Read all the related documents carefully before investing.